But in terms of your not so lengthy experience with this process, have you been able to identify whether or not these bad ancillary agreements have come from the top 1% of the businesses that the chamber is talking about here?
Let me let Mr. Henley answer that specific question in the brief experience under the new.
Senator Roth, the short answer is no, we don't have a lot of data knowing that our regulations, the ink just became dry on April 1st. We do have evidence involving filings that were made with us. We have reason to believe that not all companies are making those filings in compliance with our regulations that just became effective, probably in part because they're watching this bill closely. But for those agreements that we have seen, we can and have identified a number of instances where there were parts of those agreements that violated California law. And the good value of what we provide today is we're able to catch those before those agreements are out in the marketplace. We have a 30-day, what's called a deemer provision in terms of our review process. And that means if we haven't gotten to your review of your agreement within 30 days, it is deemed approved. We don't miss that 30-day requirement. But in the short time that we have reviewed some of these agreements, we have come across things such as arbitration agreements that don't comply with Insurance Code Section 11658.5. That's the recent law that Mr. Suchel referenced earlier. We've also seen agreements that included changes to the policy that deal with the cancellation provision that would allow cancellation, or at least purport to allow an insurer to cancel a policy under terms that don't comply with Insurance Code Section 676.8.
But since this, as I recall, these ancillary agreements cannot affect the terms of the policy, would that still be an issue?
Senator Roth, I submit that it is an issue and in a couple of ways. Number one, it's an issue in that instead of us catching the problem before employers sign on to these agreements, now the agreements will be in place before we're able to see them. And it'll probably be through consumer complaints that we learn about them where employers are aggrieved. That's the first concern. The second concern is, with respect, this bill has a lot of ambiguity around it. And so, as I think you rightfully pointed out, Senator Roth, the question of what an ancillary agreement is versus what an endorsement is a very cloudy mess now. I think our regulations clarified it to great extent, the distinctions. This bill would undo those clarifications and create more ambiguity, not only making it more difficult for employers, but increasing the likelihood of litigation and challenging courts to try to make out, should this have been filed with the department, or was this the type of thing that's an ancillary agreement that doesn't affect the policy?
Well, given the fact that the author has included a 5-year sunset, so there'll be a review of this, should this bill move out of this committee and should it move off the floor and should it be signed, there'll be an opportunity to take a look back here. So given the fact that there will be an opportunity to take a look back, what information would you need to have from the companies that are exempt from the requirement in order to study and provide a report as to whether your concerns are valid or whether they're invalid or whether there's something in between?
If I might, Senator, I'm very glad you asked that question, because despite getting on Monday at 3:30 the official mock-up finally from the sponsors of this bill, we have very quickly come up with a set of amendments that, among other things, address your very concern, which is to say, we also think the sunset ought to be shorter, because there is right now, currently, a lot of litigation out there relating to this issue. And in a minute, I'll get to the Shasta Linen case, which the commissioner just decided on Monday of this week. But if it's, with the sergeant's permission, if I might have this passed out to the members, this document is our proposed modifications to the mock-up, which we just got on Monday afternoon. And towards the end of it, we include some very reporting requirements to try to get at the very question that you're asking, because we think it is important that we have some data here and that we have the relevant entities taking a look at what we're getting and what we're not getting. What's being set up here to a certain extent, Senator, is that we would have to be omniscient about what we're not getting it and why we're not getting it. The definitional confusion that has been created with the mock-up in this bill is such that I would submit that almost any insurer can attempt to argue, you know, we don't have to file that with the department. Based on what? Well, we think that the way that this definition interacts with that one, we don't think we have to file that one. There's also a muddiness about what an agreement actually does versus what it's called. You can call an agreement an ancillary agreement, you can call it whatever you want. But, thank you, Sergeant. But what it actually does is what should determine how it gets treated. And our reg, which just went into effect 2.5 months ago, did a very good job of not talking about it's titled this or it's titled that, but here is what this ancillary agreement actually does. For example, to use the Shasta Linen case, that's a sad example where we didn't get that agreement. Had we gotten that agreement, we would have absolutely pointed out very quickly there are major problems with this. It is contrary to California law. It is contrary to California public policy. So what happened? What happened is Shasta Linen has had to spend hundreds of thousands of dollars on legal fees now because they had the temerity to stand up to this insurer, a subsidiary of Berkshire Hathaway, so shame on the Oracle of Omaha for this one, to stand up to them and say, enough is enough, this is not right.
They be exempt under this bill?
We don't know, because to be honest with you, the small business test of 3 of 4 is pretty murky. Has it gotten a little bit better? It has. I would argue that when you're talking about $2.5 million or $3 million in premium, then you're starting to begin to separate out the wheat from the chaff here, not $750,000 or now $1 million. And I've even heard that from a number of private insurers in this room who really don't like this bill, but are unwilling to say so publicly. So that gives you an idea of what's rolling around on this issue. But in Shasta Linen, we have, they got a bait and switch. They thought they had a deal with Applied Underwriters, which is the Berkshire Hathaway subsidiary. And then they used a sort of complicated reinsurance participation plan, which was never filed with the department. Once it came to our attention, we're aware of at least 50 different lawsuits relating to that very agreement or the reinsurance participation plan. By the way, they filed a patent for this reinsurance participation plan, and if you read the patent application pretty carefully, you can see the whole objective of the patent is to evade state regulation, which is phenomenal in a way when you think about it. So we have a patent, and our invention is we're going to avoid state insurance regulators' scrutiny. This is why states like Oklahoma, Illinois, Wisconsin, Vermont, and others have taken action in exactly the opposite direction. They are adding more scrutiny for these large deductible type policies, not semi-deregulating them, which is partly what's going on here today. That's also why the National Association of Insurance Commissioners, which is Commissioner Jones and his fellow commissioners in the other 49 states and 6 territories to boot, are all concerned about this enough where they've created a special task force working group. I believe Ms. Ryan quotes a little bit of their preliminary findings in her analysis, that they're very concerned. This bill, all it does, among other things, is it strongly encourages more of these large deductible type agreements, which are very risky and dangerous for some types of employers. If you want to be self-insured, then you have to go through that process, file with DIR, et cetera, et cetera. These folks are getting none of the benefits of that self-insured, and they're taking all of the risk. Under the reinsurance participation plan that was in the Shasta Linen case, what they essentially did was the insurer shifted all the burden and the risk right back onto the small and medium and even large-sized businesses. That, I would argue, is the antithesis of what insurance is supposed to be, which is assuming risk at an appropriate negotiated price. So there are many, many concerns with this. That's why you're seeing other small business organizations oppose this bill, because with all due respect to the Chamber of Commerce, I think they trust their own small business organizations a little bit more to look out for small businesses as opposed to the Chamber of Commerce. Mr. Hanley might have a couple other.
Mr. Chairman, point of order, please, okay, if I may. We're trying to have a thoughtful conversation here, okay, and do it in a very constructive way. And I've now heard 2 cases where the witness has personalized, used the term, in my view, demonized an individual almost by name, by referring to him personally as somehow involved in the illegal and shady operations. And I don't think that's appropriate. And I also think it's healthy to try to characterize the motivations of anyone that's coming before us, certainly the Chamber of Commerce. So I want to listen carefully to thoughtful testimony, but I think that we also need to be careful to conduct it in a civil way. And I would graciously ask the witnesses to try to to do so.
Appreciate that very much, Senator, and I apologize if you felt like anything was personalized. I was merely pointing out that the business community is not unified on this measure, that there are a number of small business organizations that oppose this bill because they are concerned. And many of those organizations that we have spoken with have indicated that they have an extremely hard time interacting with the workers' comp insurers.
So,
I appreciate that, Mr. Chairman, but when you refer to Warren Buffett as somehow personally engaged in illegal conduct, I think that is not constructive or even accurate in terms of a publicly traded company and somehow identifying an individual involved, and I think that's over the line.
I never, thank you, sir. I never said it was illegal conduct. What I will say is that a judge ordered that agreement, that reinsurance participation plan was null and void because it was not filed with the Department of Insurance. And that the commissioner's decision as of Monday of this week was to reinforce the notion that in a presidential decision, that if it is not filed with the department, especially this particular situation, Shasta Linen case, that it is null and void.
so before we move to, there are other witnesses, I think, who want to speak. Let me just say this. Part of the problem here is we are going to have a sunset, so we're going to have an opportunity to take a look at this. It appears to me we don't have the data necessary to determine whether that group, perhaps very small group of employers who will be exempt from this requirement, are employers that we need to necessarily be concerned about, because we don't, as Shasta Linen, we don't know whether they have, nobody's told me, whether they have 25 employees or 2,500 employees. So maybe the focus ought to be, as we move forward and folks up on the dais decide what they want to do, figuring out what information that the commissioner, you, those that are interested, need to take a look at the end of the sunset period, assuming it's 5 years, to determine whether or not the exemption remains appropriate or whether we should take another look at it. So I don't know what it's hard to negotiate amendments from the dais, and we don't do that, and I'm not going to do it today, but you know, perhaps the author needs to think about, or is willing to think about, having industry submit ancillary agreements to the commissioner without the necessity for approval, so that the commissioner can collect some data on the ancillary agreements that are floating out there from this exempt group of folks. Maybe that particular group and industry would not object to that. I don't know. I'm sure they'll tell me in a few minutes when I give them an opportunity. But why don't you close up, and then we'll have the other witnesses speak.
Senator, on that point, I would just note that we just started talking about this concept, I think, a little bit ago, and I think we would be intrigued in pursuing that. It wouldn't necessarily remove our kind of philosophical opposition, because we do think that the line is pretty bright right now. But what you're referring to, I think, is what we would call a sort of file and use situation in certain circumstances, where it would be filed with us, and at least we would be aware of all these kinds of ancillary agreements. Because the truth is that we feel like right now we're not getting a lot of these that we currently legally should be receiving.
Well, industry feels that they don't need to have the commissioner review and approve them because the agreements are appropriate, and we don't know, and you don't know. So maybe what we ought to do is find out, and if in fact the exemption remains appropriate at the end of the sunset, it continues on, and if there are issues, we can address them. But there's some gentlemen back here who I believe want to speak. Sir.
Okay, thank you very much. Senators, my name is Nicholas Roxborough with the law firm Roxborough, Palmer & Stein, Adron in opposition. Lively debate, and appreciate the opportunity to talk to you folks. I actually know something about this because I've been doing this for 30 years. And the notion that these agreements are negotiated is false and inaccurate. Why do I say that? Other than my 30 years of experience. Because I'm the one who handled the Ceradyne case that's in the committee analysis. That was against Argonaut. That was a medium-sized business, not large. That agreement was never negotiated. AIA represents to you, as do the other supporters, what? The assumption that these are large employers. They are not Safeways. They are not Walmarts. They're small, medium-sized businesses. Some of them are charitable organizations, I might add. They have no bargaining power. You know, it's kind of funny, sit in a courtroom, there's a representation that, well, this is just a limited exception. I look back in this room. This is not a limited exception bill. What has occurred here, unfortunately, through no fault of anyone, is this is a fiction that these are large employers who have the power and capacity to negotiate. I represent one of the largest brokers in the country, top 10. They can't negotiate for my clients. They can't negotiate. That's why these bills, they don't want to be filed. I was here in 1993 when we went to open rating, the Ghostbuster days, and we talked about going to open rating. And in 1995, for the last 21 years, one of the things that was supposed to occur is any ancillary agreements, whatever we want to call them, were supposed to be filed with the Department of Insurance. Why? Because they varied the policies that the state of California says the insurance commissioner must see. Obviously, if we have a contract with the landlord, it's got to be in writing. If you vary it, it's got to be in writing. The rule was simple. If you vary the terms of a policy, you must file it. The fact is, many carriers follow that rule easily. Why? Because it was right there in 11658. Now, then there was a regulation, April 1st, a couple months ago, that made very clear what ancillary agreements are. So the rule is simple. I read the purpose of this bill, and we have to go back and say, what was the purpose of the bill where the chair had a very good intention? It was to simplify and facilitate negotiations. I'm terribly sorry to tell you, this bill does anything but simplify, right? You've got more confusion. As a lawyer, I will be in court for 10 years trying to figure out what this bill currently requires and says, and here's why. Right now, all you got to do, carriers, and what they have been doing is what? They push an electronic button and they file the ancillary document, and they pay a whopping $1,000 up to, and they're done. Now the burden has shifted on the Department of Insurance, which is understaffed, to now use their resources to analyze all these problems. The ancillary bills, mentioned Ceradyne. One of the folks talked about an endorsement, and Senator Gaines, this is an endorsement. It's a one-page document, got to be filed. Travelers, member of AIA, this is the agreement they don't want to file. By the way, this is the agreement Travelers did not file. This is the agreement that told my client, a medium-sized employer in Los Angeles, to go to Connecticut, have this policy interpreted by Connecticut law, which is the most unfavorable to California businesses that you can imagine, and spend hundreds of thousands of dollars litigating it. I can't even get to the fundamental issue with Travelers about whether they did a good job or not. Senator Gaines is right. Many brokers would like this account, a small, medium-sized business. It's good commission. But Shasta Linen couldn't negotiate with Berkshire Hathaway. Any truly large business in California, folks, any true large business is self-insured. They have control over their whole system. So when this bill says its purpose is to take care of large employers, these aren't large employers. I had a case, Country Villa versus Zurich, side agreement thrown out in federal court. For anyone to come up here and say they're not supposed to be filed, the federal judge in Los Angeles said failure to file side agreements is illegal in California, and they threw out the whole agreement. Zurich, small janitorial company, DMS, similar issues. I noticed that the applicant's attorney are in support here, and they're concerned because injured workers may not get paid. Fact, not allegation, fact. In that case, there was a dispute under the side agreement that was never filed. My client said, I'm not paying for the things you're charging me for. Fact, Zurich said, we're not providing benefits. For 2 weeks, there was one injured worker who got no benefits. They were put in the middle. So actually, the consumers, or the applicants association, I believe, who's in support of this? They're right. I have a real example. One thing I haven't heard here, and it's always interesting for senators and assembly members and lawyers and so on to listen, what have you not heard? What have you not seen? You haven't seen one piece of evidence, one piece of paper from a single insurance company where they said a small or medium-sized business has negotiated, has bargained for, and achieved equality. The chamber supports this, okay? Small businesses don't. And small businesses and medium business are getting crushed. The Department of Insurance was absolutely accurate when they said hundreds of thousands of dollars, not going to jobs, not going to take care of payroll or people, not paying for benefits, just trying to be treated fairly by these folks. I've done this my whole career, and I've represented businesses in California against insurance companies. This bill also now says that the carriers get to decide whether they file the ancillary agreements, right? The carriers do. So a couple of questions. If this bill is going to come out of this committee, at page 4 of the bill, paragraph number 7, remember the carriers said they don't want to be bothered with filing the agreements, but this bill says the carriers still have to do what? They still have to notify the department that they're not filing an ancillary agreement, which is sort of strange to say, I don't have time to file an agreement, but I have to file a notice, I'm okay with that. So maybe what do we do is when they finally have an executed agreement, we have specific language that says you file the notice with the department and you provide the Department of Insurance with an executed copy of your ancillary agreement, and at least the department can then have it and look at it, even though the agreement's already been in effect. But the problem is, while that helps and gives the department valuable information, their job is to regulate. The carriers are not supposed to decide what is or what isn't. The case that the DOI mentioned where the court held the Berkshire agreements unenforceable, that was also my case. I've got all the cases in California. San Francisco Judge Harold Kahn said, throughout the Berkshire arbitration clause saying it's not filed under 11658. Case over. It's so simple right now under California law, and we're making things very, very complex for everybody. Yes?
As I've indicated, I'd certainly support collecting some data on this, so at the end of the sunset, when we're back in here deciding whether to extend it, we know what we're talking about. Because I haven't, other than anecdotal stories, I don't know whether these nasty ancillary agreements are rampant in the top 1% or top 2% or whatever the percentage is that we're talking about of businesses that are excluded from the provision.
So we're excluding, Senator Roth, we're excluding, I know Zurich and Testimony said they had 2,100 every year of these. That's just one company. High deductibles, loss-sensitive plans, 2,100.
500 or more employees, 20 million payroll.
Pretty much almost all the deductible folks are in that category.
We'll have an opportunity to take a look at that, with or without data, if the sunset remains in about 5 years if the bill passes.
Well, it's a great point, my last point, because I truly appreciate the opportunity. I know how busy everybody is. You're taking out from the Department of Insurance 5%, 10% of the market, 50, 60% of the dollars. We all have that rule, 20-80 rule, right? 20% of your clients cause you 80% of your problems. You got a small percentage of people who don't now have to give the department this information, but we are dealing with an enormous amount of money at stake, which is very, very different. And I wish, please give that serious consideration, because for 100 years under the workers' comp bargain, employers made a deal. They can't be sued civilly, they'll take care of the injured workers. But the carriers are supposed to uphold their end of the bargain. And this little exception, with all those folks in the room, is worth hundreds of millions or billions of dollars. And the Department of Insurance, which we have laws right here, telling them to audit and oversee what goes on. They can't do it. This little exception takes away 50% or more of those dollars. And that's not what this bill is supposed to be about, because this bill doesn't facilitate negotiation. I appreciate it. If there's any questions?
Alex, you want a question before we get to the next speaker? Go ahead.
I guess my concern is the effect that it has on the open rating law, because you
Yes.
stated it when it went in. And if the commissioner doesn't have this data at all, and let's just say it only affects 5% of the players, but it's 50% of the market, how is that going to affect the ability to set these rates in a fair way?
Well, that was my last point, that I saw people getting a little impatient, but that's a sophisticated question. It renders what the Department of Insurance does almost meaningless. You've got information coming in, and they and their statistical agent, the Workers' Compensation Insurance Rating Bureau, statutorily created, has to give us all this information. Now you're excluding 50% of the information. We're still going to get information for the department. It's not going to be very reliable or useful. That, we can't wait 5 years to find out what happens. We've had the crashes of workers' compensation carriers, 28 in the 15 years ago or so. That was awful. SIGA, Mr. Wilson, his company had to come to the legislature, ask for billions of dollars. This little exception that AIA talks about, this has huge minefield consequences. Your question, Senator, fabulous question. The answer is it distorts, if not perverts, the information we're getting from the DOI. That should be studied. Perhaps this bill should be laid over for more study on the impact, because there's a huge financial impact for the state of California. Thank you for the question.
How does I'm not a sophisticated guy, he's much more sophisticated.
Okay, that's like on the golf course, right?
You're talking about ancillary agreements,
Yes.
and again, I'm not a broker. Agreements that cover choice of venue,
Dispute
things like
resolution
that,
clauses.
dispute resolution. How does that affect the open rating system?
Okay, a couple, directly,
It's not loss experience.
no, it does, that directly, that question, it does not. Here's the fact, though. Every Travelers, AIG, you name all the large players, they all have dispute resolution clauses in them. So the notion that it can be bargained for as a broker, say, well, Travelers, I'm not going to take that out. Why? Because they want you to go to Connecticut. You go to some other company, they have the same arbitration clauses. It's like the credit card company. In theory, we can negotiate, we can go to another credit card company, but for the most part, we're kind of stuck. Small, medium-sized businesses get stuck every day. Large businesses get self-insured and get out of the market. You look at the data, more employers in California are now self-insured. So this bill is directed to small, medium. The fallacy, the fiction is that these are the Safeways and the Walmarts and all those folks. They aren't there. They're all self-insured at the Self-Insured Security Fund under OSIP, the Office of Self-Insured Plans.
Okay.
Thank you very, very much.
Mr. Vice.
Yeah, of course, Senator. Thank you.
Define an employer with 500 more employees as small.
Because the power,
I look at the marketplace here, and clearly those are, anything under 500 is still considered a big account. A 400 employee account would be a huge account for a typical broker in the region.
great question. Huge account for a broker, make commissions or menu shopping, yes, you get $50, $60, $70, $100,000 in fees, but no power to negotiate. This bill is about,
We're talking about accounts over 500, 20 million in sales, and I would think the sophistication with that type of account should be clearly different than something that falls below that. That doesn't satisfy the criteria that have been set up in the legislation.
what Senator, you were talking about was claims handling issues. They have risk managers to oversee claims handling. They're on their claims. You're 100% correct. They have sophistication. They know what they want. You can't get it. I know what to get from a credit card company. I can't get it. You would not be able to negotiate any of these clauses out because every other carrier out there has these policies and programs in place. But yes, in terms of, is the account worth money in terms of commissions? Yes. The power to negotiate and bargain for, that's what the committee analysis talked about. As I read it, it talked about they're large employers and therefore they can negotiate. That's the assumption. There's no evidence of that.
But we've got employers asking for it. We've got the California Chamber endorsing the legislation. So it,
You have small businesses endorsing it, and I will say this delicately. I was a member of the California Chamber 20 years ago. Insurance companies are employers. They come first. And the California Chamber did not call me. The California Chamber did not call my clients, did not call the charitables, did not call the nonprofits. This is good for insurance companies. This is not good for small and medium-sized businesses. I know that firsthand because I'm in the battlefields every day. But yes, but remember, small businesses are opposed to this
Okay, how are you defining small? Because you're
because they can't.
over 500.
I would define.
500 employees is small in your definition, so I'm not clear as to how you're defining it.
It doesn't matter what you call it. The issue is how big do you have to be able to negotiate?
Yeah, I think that's a fair question.
And my clients can't negotiate. Every one of them got the agreements thrown out, but none of them were negotiated. None of them. AIG, Monarch Case, Zurich, Travelers, Berkshire, and so on.
Okay, all over 500 employees.
I think not only over, I think that they were 250, one was a $500,000 deductible, around that range. They were all would have qualified, and these agreements would never have to have been filed. No power to negotiate. Oh, by the way, they had brokers, because brokers have to represent you. We have to buy workers' comp as a matter of law in California, and brokers are there. So the fact that you have a broker is not a condition that's of any relevance, because every employer has a broker, has to have a broker, except for state fund, because it's a direct right. So the fact you have a broker doesn't mean anything. I'm a lawyer, and they say I'm kind of good. They say I know what I'm doing. I can't negotiate these.
Okay, thank you.
No, I really appreciate thoughtful
Chairman,
questions.
May I speak with respect?
Absolutely fascinating conversation. We are going to have to move on, but I absolutely speak.
Steve Suchel, American Insurance Association. With respect to the rating, this bill does not exempt the filing of ratings with the Department of Insurance. Ratings are not excluded, so any rating information under the bill would still have to be filed. There's nothing to do in this bill with rating, number one. Number two, the focus in this bill is on large employers and not medium and small employers. If there are issues with those employers, they will be dealt with. But in this case, the bill is aimed at large employers who do have the ability to negotiate, and very often we're talking about agreements wherein the employer is asking the insurance company for frequent changes over the term of the policy. Thank you.
So before we get to this very patient gentleman in the back here, how do you feel about asking you all to provide the ancillary agreements to the commissioner so we can do some data collection in preparation for our sunset review?
As the bill stands right now, Senator, the department has, if it were to be enacted, the department has the authority to ask for the policies. There is a notice to the department in the bill now that says that when an agreement is executed, it would go to the department asks for it. So further than that, I'd have to revisit that, but I think that the department has the authority to ask for the agreements. Also, I want to make plain under this bill, also the department is not losing any of its oversight or regulatory authority. There is nothing that's being taken away with respect to financial, market conduct, or any other activities. We're just talking about, we're not going to drop into the abyss of insolvency or problems. All this bill is a simple exclusion from filing for a very small slice of employers, and the department retains its full authority. Sorry.
You know, we had a former Secretary of Defense who once said, "You don't know what you don't know." So you might want to consider whether the industry would be willing to submit the ancillary agreements just as a matter of requirement without any necessity for approval or review, so we can do some data collection. So the next time we gather at the river here, we can talk about data and whether, in fact, there are bad ancillary agreements out there by the top 2% or 1% or whatever, would be my suggestion. But again, we don't negotiate amendments from the dais, so that's up to you all.